Hello everyone, and welcome to the last class of IS350 for this semester. So today we'll be talking about intellectual property, and this will essentially be the bookend to the class. First though, some announcements about student presentations, course evaluations, reminder about your updated personal code of conduct, and the final report. So for student presentations, I have reopened the student presentations discussion forum. It was originally closed and locked automatically last night, but I went through and reopened it. I'll leave it open for the next few days. Please, this is your last chance to post comments, review any of the presentations that your fellow students post, and critically, if you are a presenter that has posted on here, be sure and respond to some of the questions that have been asked here, because that is part of your grade. Otherwise, you are done with current event presentations, and that's it. For course evaluations, just a reminder, the short course evaluation, the survey, the anonymous survey I posted, 14 of you have taken it. Thank you very much for those who have. 21 of you, or I think there are about maybe 20 or 19 of you, still haven't taken it. Please, if you have a moment to go through and just answer these quick questions, it's hugely helpful for me. Secondly, about the NJIT course evaluations, so the current response rate as of 10:51 in the morning on Wednesday, the 29th, today, 35% of students have responded to the evaluation. So also please take a moment to fill this out if you have the chance. This is not just useful for me, but also useful for the university. All right, so for your updated personal code of ethics, just a reminder, it is due today at the end of the day. Primarily it's a quick update and a reflective post or a reflective assignment about your original personal code of conduct and whether today's or this class over the course of the semester has impacted or changed any of your thoughts on this. But please get that in today. There is no rubric. It's mostly just my reviewing your answers and looking for your insights. Just a reminder as well, the IS350 final exam is a report that is due in Canvas on the 13th of May. So that is in 2 weeks from today. So be working on that. If you have any questions, definitely reach out to me via email. Feel free to post in the discussion forum, whatever you want to do, but please take a moment to familiarize yourself with the questions that I'm asking for, the rubric, and I've even provided you a sample for it. So if you have any questions, like I said, please reach out. Okay, so for class today, we'll talk about a couple of things. So in the first part, we'll talk about what is intellectual property and why do we protect it. And in the second part of it, we'll talk about fair use, open source software, and the Creative Commons license. So first, some learning objectives around intellectual property. The first thing I want you to be able to do is succinctly describe what it means to own some piece of property. So this will actually become maybe more confusing to you when we do this discussion, because owning something is more complicated than it may look if you try and succinctly and clearly define what it means to own something. Secondly is to define intellectual property, differentiate ownership of tangible versus intangible things. Why is there a difference here? List at least 2 reasons why we have protections for intellectual property. Describe the 4 protections for intellectual property. Differentiate copyrights and patents. And describe why the internet has had a major impact on intellectual property protections. Okay, so first let's talk about protecting intellectual property. These are some discussion questions or some thought experiments for you. So do you own a sweater that you knit? You buy some wool, you have the tools to knit a sweater, and then you knit a sweater. Do you own that thing? Do you own your home? So perhaps you didn't build your own home, but if you purchased it, do you own it, or does the mortgage that you may have gotten with the bank mean that the bank owns it? If you are an apartment, you probably rent, but maybe you are in a condo where you didn't build the building, but you pay for a space within the building, or you're in an HOA or some sort of condo complex. What does that mean? What does it mean to own in that space, where maybe you don't own the physical property, you own a right to some space? Do you own a book you bought on Amazon? So in some sense, sure, you went to Amazon, you purchased a book, now you have that physical book in your possession. But do you own it? What does it mean to own it? Certainly, no one from Hollywood is going to come and ask you for movie rights to this book just because you own the book. But why is there a difference here? Do you own the photos you take? So with mobile phones that have really good high resolution photo cameras, you can take many, many photos. My wife, for instance, has millions of photos, probably most of which nobody has ever looked at since the first time she took them. But does she own them? Or if they're on her device and she puts them on Google Photos, does Google own them? Where do they exist? Do you own the tweets you post? So this is a more interesting question. So similar to the Google Cloud analogy or Google Cloud example I just provided. So if I take a photo and post it to Google Cloud, I own it to some degree, but I've given Google the rights to analyze it in some sense. With tweets, perhaps I authored the tweet and then I posted it online, but I'm using Twitter's platform to do so, and the data behind that tweet goes into a server on Twitter's infrastructure somewhere, and they own that infrastructure, and if they did not have that infrastructure available to you, you wouldn't have been able to post that tweet. So who owns a tweet here? And even more complicated, who owns a retweet? So if you retweet somebody else's tweet, what part of the tweet do you own? Well, it turns out Twitter has some answers for you about this in their terms of service, that you retain the rights to any content you submit, post, or display through the service. What is yours, where you own your content, and your incorporated audio, photo, and videos are considered part of the content. So they're pretty clear that they're trying to tell you, you own the content that you post on our platform, but you give them some rights to it to be able to display it or potentially analyze it, these kinds of things. Still, this doesn't answer the question about who owns the retweets, because if you retweet something, you own maybe the content you added, but do you own the content that the other person posted? Especially in today's version of Twitter, where when you retweet, you have a native retweet capability where you get your content and a little panel showing the original content. So what does that mean? Do you own your textbook? So maybe you might have a more intimate understanding or feeling about this, or stronger feelings about ownership in textbooks, especially when they have electronic textbooks or textbooks that you can sell back, or textbooks that you can rent, or textbooks that come with codes that you have to have in order to access online services. Do you own an app you buy for your phone? So this is similar to the Amazon case, where there's an app on the App Store or on Google Play. You pay for it, and now it's on your phone. But do you own it? And what does it mean to own something? A question here is, can you sell that app to someone else? This is how we start to differentiate between the Amazon book and the app from the App Store. So presumably, if I buy a book from Amazon and I get a physical copy of that book, I can sell it to somebody else, or I can go to a used bookstore and trade it in or something. Can you do that with apps? In the general sense, no. Certainly it is possible if you're doing like side loading or something like that, but in the general sense, I think the answer to this question is no. And in fact, if you go look at Apple's license agreement, they're very clear that you don't actually buy an application. Apps made available to the App Store are licensed to you, not sold to you. So you don't actually own that app when you download it, even when you paid money. Even when you paid potentially substantial amounts of money, you still do not own it. Do you own a book you write? So going back to the idea of the sweater. So a sweater has some tangible thing to it. There is a sweater that you've created. It has some sort of material that went into it. So maybe you could make some strong argument that you own the sweater that you make. But if you are writing a book, this is different in some way. So if I write a book, and then I print it out or have it bound or whatever, there is a printed copy of the book that I may be able to give away, or that somebody could take from me. So someone might be able to steal the physical book from me. But the ideas behind the book, or the narrative, or the story, or the characters, do you own those as well? What does it mean to own the idea or story behind a book? And how does this change if I paid you to write it? If I, as publishing company or a newspaper or a university, asked you to write a book for me, maybe it's a textbook, and then you write it, who owns it? Do you own it since you wrote it, or do I own it since I paid you to write it? And we can get more complicated with this class, or with these examples. So you've written a number of papers for me over the course of the semester. Who owns those papers? Do you own the papers because you wrote them, or do I own the papers because I gave you the prompts and you're writing it for me? Does the university own the paper because you worked for the university during that time? It's not entirely clear. Same thing, since most of you are technologists, do you own the software that you wrote for school? So for papers, maybe you're less interested in this, but maybe you are doing a senior project, or you're a master's student or a PhD student, and you are writing a piece of software as a big project for a class, or as I said, your master's project or your dissertation. Who owns that software? Do you, since you wrote it, or does the school? Since the school's not paying you to write it, you're in fact paying the school to have the opportunity to write it, at least in the undergrad and master's sense, or master's perspectives. So who maintains ownership there? This changes a little bit when you are getting your dissertation, because generally the school's paying you to do research for them. So there's a different aspect of this argument here for PhD students. So if we go back up to a higher level sort of abstraction, what property do you own? So given all these different kinds of examples, do you own anything? What is property at all? Is it the book? If you wrote the book, is it the physical copy of the book? Is it the idea behind the book? It's not the apps on the App Store, but what about the photos that you post on Google Cloud, or content that you post on Twitter? What pieces do those count as property? Can you own them? What does that mean? So yeah, this really sort of abstract and maybe potentially esoteric question of what does it mean to even own something? So we have this question about what is property. Is a photo you take and post on Twitter property? And then if you take that photo and somebody else tries to repost it, or somebody takes a screenshot or saves it, are they stealing from something from you because you own it? So what does it mean to own that thing? So it turns out ownership is a non-trivially complex kind of topic. If you go to Wikipedia, they state that ownership is the state or fact of exclusive rights and control over property. So in a similar kind of way when we talked about privacy, that privacy is a zone of control around your person, and you have some amount of agency in being able to say who can come into that zone. I can control some amount of information about me. The same kind of thing applies here, that it's the ability to control something, particularly property. So some questions that come with this is, if you own something, can you sell it? Can you make money from it? Can you profit from it? So this helps you sort of guide the answers to these questions that I asked you before. So if you take a photo, can you sell that photo? And the answer is yes. Maybe you won't get a whole lot of money from it, but potentially you can profit from it. Same thing with books. There's the physical copy of the book. There's also the story behind the book. So like Marvel owned the idea for the Marvel Cinematic Universe, and then they sold it to Disney, or they sold the intellectual property to Disney, even though it's not necessarily a tangible thing. So we'll get into like what these mean. But we still have to have some sense of property. What does it mean? What does property mean? What constitutes property? So again, we go back to Wikipedia. Property is a tangible object, an item, a piece of land, real estate, but can also be intangible things, intangible objects like art or artistic designs or artistic creations, or, quote, creations of the mind. So this is an important distinction, that it doesn't have to be a thing that you can touch. It can be an idea. So it doesn't have to be just the piece of art, but the image of the art. So, for example, the Mona Lisa, there is the physical instance of the Mona Lisa that sits in the Louvre in France, but whoever owns that picture also, or that painting, also owns the rights to its likeness. Somebody can't come and take a photo of the Mona Lisa and then try and sell it, even though nothing is really being stolen there in a physical sense. So we've talked about social contract theory, and John Locke at the beginning of this, he actually has a lot to say about property. So in his two treatises on government, he talks about this, that in the second treatise of government, people have basic rights to life, to liberty, and the accumulation of property. So property, or being able to own property, is some sort of basic right, even though property isn't necessarily like a clearly defined thing. Now, these basic rights apply as long as nobody claims more property than they can use. So in the sense that we're talking about tangible things, this makes a lot of sense, right? So nobody can claim all the world's land, or all the world's clean water, or something like that. This would be an unethical thing to say, well, all this water that everybody needs, I claim it. One must leave enough and as good for others. So related to this, nobody claims more property than they can use, then one must leave enough property, and property in good condition, for other people to use. So this like amassing of property is an unethical and potentially unlawful thing from Locke's perspective. And then lastly, one may only claim property through one's own labor. Whatever labor means, again, labor is nebulously defined. Is it physically working on something? Is it I'm paying you to do something, and that's some kind of labor? It's not entirely clear, but the idea is you can only claim property that you're somehow associated with, or that you somehow assisted in it, in that property's coming into being. But again, property is complicated. So property is talked about as a basic right, but if you try and look for definitions of property, you end up in these black holes like on Stanford's Dictionary of Philosophy, where it goes on and on about property, starting with Locke and going into many philosophers and legal scholars over the past several hundred years. When we talk about property, though, as I mentioned, we've made this distinction between tangible and intangible things. So tangible things like land or real estate or physical things that you can touch, versus intangible things. So can intangible things be owned? We've talked about this to some degree, but when you write a book, do you own the idea behind the book? When you write music, do you own the recordings of that music, or do you own the actual sound, or the idea of the sound, or the concept of a particular set of notes? Do you own the software that you create, or do you own the physical instances of the CDs? It's not entirely clear. Same thing with artistic design or architectural design. So if I'm an architect and I design a house, do I own the physical blueprints, or do I own the idea that is cast onto the blueprints? And there's an important distinction here, because if somebody steals the blueprints from me, do they then have access to the idea? In some sense, yes. If somebody buys the blueprints from me, it's not entirely clear. I've not lost access to the blueprints. I still have the idea of the design in my head. So it starts to break down. And then when we talk about, especially relevant now in terms of medicine, so pharmaceutical companies make huge efforts in developing new medical therapies or vaccines, especially important now. But there's an interesting question about, do pharmaceutical companies own the actual chemical that makes up the medicinal therapy, or do they own the physical instances of the pills? When you buy a physical instance of the pill, you don't take ownership of the chemical compound and the rights to create it, do you? Or do you? It's not entirely clear. So, as is generally the theme in this class, things are complicated. So we can talk about property and, quote, creations of the mind, but Locke's idea of owning property as long as these three things hold, nobody claims more property than they can use, leaving enough and as good for others. What does this mean when it comes to creations of the mind? So can I claim more ideas than I can use for a book? So if I'm talking about like writing books, especially if they're fiction books, one can't possibly claim all characters and all stories in the universe. But if I am like Stephen King and I'm writing a huge number of books, it's not entirely clear what this means, right? How do we talk about using more ideas than one can use, or claiming more ideas than one can use? In terms of as good enough for others, if I own an idea, am I taking other ideas from somebody? Am I preventing somebody else from coming up with their own ideas? And then one may claim property through one's own labor. Makes sense if you're talking about creating a tangible thing. So in the sweater example, you're physically knitting something, but how does this apply for writing software or books or plays? Where does the labor come in? Is the labor you're putting your fingers to keys and writing it down? In which case, is it the document you produce that is the owned thing? Or is it the idea that you spent time cultivating and the labor you spent is purely intangible thought labor? So this starts to break down. So this gets us into this realm of intellectual property. So intellectual property is this idea of a creation of the mind. We have inventions, literary and artistic works, symbols, names, images, designs, all these kinds of things that aren't necessarily tangible. They're things that I spent mental bandwidth in developing. And so this it's an intellectual asset. The idea is the property. Now, the property protection for intellectual property applies to these intangible creative works, not the physical form. So when we talk about intellectual property and its protections in this class, what we are talking about is not the book. It's not the physical book that you can touch. It's not the pill, the physical pill that you can hold in your hand and ingest. It's the idea behind it, or the design, or the invention. Again, not the tangible invention itself, not some physical realization of the invention, but the schematics, the blueprints, or the idea of how you build it that is being protected by intellectual property. So we'll sort of short circuit this idea of tangible versus intangible because, as I mentioned, this analogy or this similarity of tangible and intangible breaks down, and the ideas of property start to break down. And we can see an example of this. So on the right side of the screen, you see a typewriter. On the left, you see a ring, right? A ring with a gemstone. So when we talk about tangible versus intangible, or tangible versus intellectual property, with a ring, you're mining for a gem and you're mining for ore. So there's real labor going on. You have people in the ground trying to bring out these precious materials. Then you have some additional process where you are smelting ore, you're applying some process to the ore to transform it. You're cutting a gem that, again, takes some physical substance in its raw form and transforms it in a really substantive way. And then you cast all that into a ring, so you create something here. But with an intangible thing like a book or a story, you see how this starts to break down, right? So what does it mean to mine words? You're not taking some raw material. I mean, words, what does it mean for a word to be raw material, or for the constituent pieces of an idea to be raw material? Now, you can claim that you can still smelt words into prose, that there is some effort or labor that goes into taking these sort of unconnected concepts or words that we have, and then putting them together in a transformative way to take what is a potentially random smattering of words in the dictionary and putting them into a coherent story. And then you can cast that story, that collection of words, into an instance of a play or an audiobook or a movie adaptation. So there is some sort of transformation here. But these same kinds of things of you start with some raw material and you produce something at the end is really difficult to clearly apply to this idea of intellectual property. So if we talk about Locke, his property definition doesn't really apply, or doesn't easily apply, to this idea of intellectual property. Some examples, like if Ben Jonson and William Shakespeare simultaneously wrote down Hamlet, who owns it? Now, we already talked about technology in a historical context, talking about Leibniz and Isaac Newton, who ostensibly came up with calculus simultaneously. Who owns the idea for calculus then? With Locke's property definitions, it's not possible for somebody to come up with something, for two people to come up with something simultaneously, because there's a limiting factor of wealth or material or something that's being transformed. What is being transformed here? Who is taking something from somebody else? So who really owns it? And if Ben steals the play from Will. What does that mean? Will still has the play. He still has the idea for the play. Maybe he has some copy of it somewhere or some draft. And if Ben has taken the physical instance of the play, what has Will lost? He hasn't lost the idea. If Will were to sell the play to Ben, the same kind of thing applies, right? Will hasn't lost the idea. He still has access to the idea. So what does it mean here? And then there's other more philosophical questions about, should you be allowed to benefit from your intellectual property? So if you have some idea, can you benefit from that in the same way that you can benefit from the realization of that idea? So the story you have in your mind, and then you write it down into a book, or you produce a book, certainly you can benefit from the sales of that book, but can you benefit from just the idea as well? This is pretty clear when we talk about ideas for books or music or software or designs, but maybe this is a little bit less clear when we talk about medicine. So if I'm coming up with new ideas for medical therapies, if I own the idea for that therapy, that means I have some control over the idea of that therapy. And if I have some control over it, that means I can deny certain people access to it. Either people who don't have enough money, or maybe I am a proponent of eugenics and say, well, people of certain races, creeds, or ethnicities can't have access to my medicine that I've created, or this medicinal therapy that I've envisioned. And certainly the last example here is not ethical. But who owns this idea of, well, once we've created something that has the potential to help people, do I still own it? Should I be allowed to benefit from it? And if so, how much? Is there a limit to how much I can benefit from it? At what point do we trade off the individual benefits versus the social good? So this gets us to this idea of protecting intellectual property. These protections give creators rights to their inventions, and the argument for this is by giving people rights to their inventions and some amount of control over it, then it stimulates creativity. We've provided an incentive for people to create creations of the mind, right? Society benefits when these inventions are in public domain, though, so if a new invention is created, that will help either reduce labor or make development more efficient, all these kinds of things. Society benefits by having access to those inventions. So we have to compromise, right? And in the United States, Congress has done so, has created this compromise, by giving authors and inventors rights, protections over their intellectual property, but only for a limited amount of time. So they have some initial time period where they can control who has access to it, or who can use this particular property. But once that time period expires, things enter into the public domain. Inventions or stories or ideas, these kinds of things, enter into the public domain, and anybody can use them. So as one example of this is the Walt Disney example, which is actually a major driver for this, for the whole concept or discussion around intellectual property. So when Walt Disney first came up with the character of Mickey Mouse and began to monetize and create art around this character, you could make an argument there's a real claim for the need for intellectual property, that other people shouldn't be able to come in and benefit from Walt Disney's efforts to create this character, give this character a life, and put all of this effort into marketing this character, getting people to be interested in this character, only for some other random person to come in and then start to use this character design as well. And part of that is you want to incentivize people like Walt Disney to create these characters, give them the ability to make money off of it. But at the same time, you want to also empower them to protect the kind of character they want to create. If somebody then came in and created a movie where Mickey Mouse is some sort of psychopathic killer who's going around and killing all the other mice in the kingdom, that would be very anathema to the character that Walt Disney's created, and you would want to provide him some amount of protections for that. But at the same time, Walt Disney and the Disney Corporation has gotten a lot of flack over over the years for being too draconian and going too hard on the protections of this intellectual property. So at what point in time does Mickey Mouse enter the public domain? Certainly it hasn't yet, and the Walt Disney Company has put in, or the Disney Company has put in a huge amount of effort to keep it that way. So how has the Disney Company used these protections for intellectual property to maintain their control over the character of Mickey Mouse? Now, before I get into this, I will say there's an important ethical argument here, or a number of ethical arguments. So, like, should we provide intellectual property protections at all? So I already showed you a couple of arguments about why we should, in terms of giving content creators incentives to continue to create content. From a Kantianism perspective, or from Kant's perspective, these protections are consistent with things like the categorical imperatives, right? So the second categorical imperative is we don't want to use people as a means to an end. We want people to be ends in and of themselves. So if we're content consumers, we want to make sure that content creators, people, are also satisfied with the use of their content, and that they should be compensated for creating such content. That if we were consuming their content without compensating them in any way, then we would just be using these people as a means to an end, the end being our own enjoyment. So from a Kantianism perspective, it is ethical to provide these sort of protections for intellectual property. From an act utilitarian perspective, I think it's enough to say that without protections, then people would be less inclined to create this content, and creating new inventions or new ideas certainly has a social good aspect to it. So there's some value there. From a social contract theory perspective, it's pretty clear from Locke's perspective that, well, you have the right to ownership of property. So the question becomes, like, what is the property that you would own? How do we define that for intellectual property? So you might be tempted to say, well, intellectual property protections are just a way for corporations to make money. And that's not untrue, but there is an ethical reason to have content protections. In the realm of this class, where we talk about things are complicated, it's when you go too far with the protections that things start to break down and you move into an unethical area. So what kind of protections exist, and how might they be abused and used? So there are questions here. We talked about how Congress has provided limits on how long content creators or intellectual property creators maintain control over their ideas, over their intellectual property. But how long should that protection apply? So in the early period in the United States in U.S. history, we had content protection, or we had intellectual property protections for books and prints. And generally this protection that you received as the creator was you got 28 years. So if you created a book or an idea or a story, then you had 28 years in which to monetize that. And after 28 years, your story would move into the public domain and people could use your characters or your story for whatever they wanted. And that's potentially valuable. In the early 19th century, in the 1830s, we see a bump, though, from 28 years to 42 years. Ostensibly, if I'm a content creator, I've created some idea in my 20s, I should be able to monetize that for maybe for my lifetime, because I'm the originator of the idea. But maybe after that, after I pass away, then things are different, and I no longer lose something for the idea if other people start to use it. So once I pass away, then protections should lapse and things should go into the public domain. And we saw, you see in the early 1800s, that these kinds of protections don't just apply to books and prints anymore, but also to sheet music. Again, this idea of I am a composer, I've created this music. It's more than just the notes on paper. I should be able to benefit from the creation of this thing. And as we get later into the 19th century, the later 1800s, the same kind of protections begin to apply to photographs as cameras become more popular. And in the early 20th century, we start to see copyright protections jump from 42 years to 56 years and then apply to all kinds of literary works, but also to recordings like motion pictures and sound, and to companies. This distinction of an individual ownership and a corporate ownership becomes important, because before maybe we were making arguments about you keep control over an idea until you pass away, but corporations don't pass away. So what does this mean from a company perspective, and the original arguments for this? And as we get later into the 20th century, we start to see these protections apply to computer software, and then it jumps from 56 years to 75 years. We have this introduction of automatic renewal, that when you have an idea, if it is going to lapse in terms of protection, before maybe you had to apply to maintain your protections, now it just automatically renews until something happens or you do something to stop these protections from being applied. And in the late 20th century, protections went from, or years of protection went from 75 years to 95 years. So I think we start to lose the original thread of the argument about, well, you want to protect the individual who created the idea, but is 95 years too long? And I think, at least from my perspective, 95 years is probably too much time, especially in the realm of technology and computers, where everything is changing so quickly. So despite these, or in addition to these years of protection, how else can you protect your intellectual property? So there are four main ways. There are four main classes of protections of intellectual property. The first is trade secret. The second is a trademark or a service mark. The third is a copyright, and the fourth is a patent. So we'll break these four things down. So trade secrets are confidential pieces of intellectual property. So it's you can imagine the recipe for Campbell's tomato soup, or the recipe for SpaghettiOs, or the recipe for Coca-Cola. These are all confidential, they're secret, and that's the main thing their secrecy is the main thing that drives their value. And by having access to these secrets, that the company who has the secret has some competitive advantage. Nobody else can create Coca-Cola, and even if I, as some random individual, wanted to, I couldn't create Coca-Cola by going and looking at some recipe somewhere and trying to make it myself. A key point about trade secrets, though, is that they never expire. But there are some downsides, right? So if you're thinking about this from a content creator perspective, you may think, oh, trade secrets are great. If they never expire, then I always have control over it. This is excellent. But not all things, not all kinds of intellectual property are appropriate for trade secrets. So certainly this wouldn't apply to movies or stories or music or software, or pieces of software or images or pieces of art that are meant to be shared. It makes no sense for those things to be secret, because their whole value is in sharing them. Critically, reverse engineering is allowed, right? So if I create Coca-Cola, or if I create some new kind of battery, and I don't tell people how this battery works or what the recipe is for Coca-Cola, somebody can still take it, try and reverse engineer the recipe or the technology, and then bring that own version to market. And then you have a difficult situation, right? Because if your recipe or your idea is secret, you can't necessarily claim, oh, look, this is how ours was made, and this is how somebody else makes their competing product. They're the same. Because you have, in theory, nobody would know what your item was, or what your recipe or plan was. So, and there's not very much difference between, or how do you differentiate reverse engineering from research? So in this case of trade secrets, then reverse engineering is allowed. Somebody could reverse out how to create this idea. And if somebody comes and works for you, they are exposed to the idea, the secret information, and then they leave to go work for another company. You can't just remove those ideas from them. So these trade secrets could be compromised when companies come and go, or when employees come and go. And this is one of the major arguments against the FBI forcing Apple to unlock or include some mechanism to unlock phones through backdoors, because somebody who works for the FBI who then sees how these backdoors are unlocked by law enforcement can then go work for a private company and compromise all kinds of security features that Apple's provided. So these kinds of trade secrets, or keeping things secret, is what's called security through obscurity. That by keeping other people from knowing something, we're protecting it. But this doesn't apply to everything. Or rather, it's not good for everything. The next kind of intellectual property protection is called a trademark or a service mark. A trademark identifies some good, so this is the TM that you see on something. Service marks identify some service, it's called SM. Often you see them on like names of companies. And companies can establish this brand name idea around these trademarks and service marks. Again, they don't expire, like trade secrets, but they can be lost. So if a trademark it becomes so commonly used or so commonly associated with a particular item, then where all of society starts to call that item by this moniker, then once this moniker has become so common, you can no longer trademark it. Companies advertise as a result to protect their trademarks. I'll show you an example of this in a minute. And then in order to maintain your trademark, companies also have to prevent other people from using them. So it's not enough to just advertise. You also have to show that you have tried to prevent other people from using your trademark. Now, a good example of this is the Nintendo. So when the Nintendo came out in the 1980s, the Nintendo game console or entertainment system came out in the 1980s, Nintendo, a company, already existed. And you see in this picture the circled R at the right side. That's not a trademark, that's a copyright, because Nintendo is the name of the company, and what they tried to go after, one of the things that they tried to do to incorporate or maintain their trademark for the Nintendo Entertainment System, you can't see it on this picture of the NES, but if you look at the system very closely, there's a TM on that. So that's the trademark, the Nintendo Entertainment System. Now, what they did was call this a game console. So Nintendo was very adamant that the NES wasn't a Nintendo, it was a game console. So that way, when the public referred to this kind of technology, they would refer to it as game consoles. And when people would talk about the Nintendo or the Nintendo Entertainment System, they were referring to a very specific item. So this way, when the Commodore 64 came out, or a competing game console came out, that they wouldn't also be called Nintendos or NESs, and then Nintendo lose their trademark for the Nintendo Entertainment System. All right, so you saw the R that I just mentioned. This is what's called a copyright. So you may already be familiar with this, with things like copyright infringement, these kinds of things. What is a copyright? A copyright is a legal concept that defines rights to certain kinds of intellectual property that protects creative works such as books, articles, plays, songs, works of art, movies, and software. So this is the typical kind of thing you may think of when you think of intellectual property in terms of movies or things that are on the internet, pieces of information, these kinds of things. These all have copyrights that apply to them. When we talk about the years of protection before things come into public domain, generally we're talking about these copyrights. So the 5 kinds of control, or the 5 rights that you get through owning a copyright, are rights to reproduction, rights to distribution, rights to public display, rights to public performance, and rights to production of derivative works. So a really good example of this is the NFL. They are very adamant about their copyright. They basically say that any instance or any image of an NFL player or anything that goes on within a game in the NFL is all part of their copyright, and the NFL is very adamant that they control the reproduction. You can't record and then replay their game without their permission. They say this, I think, at the beginning and throughout their advertisements in their games. They control the distribution. They control who has access to public display and who can display recordings of their games, who can perform their games, and then any sort of derivative work. So even they claim using content or using videos from NFL games to produce news stories or to make documentaries about the evolution of the game. All of these are derivative works that are not necessarily instances of football games. Copyrights allow you to control that as well. We'll talk a lot more about copyrights in a minute when we talk about fair use and some other things. The last kind of protection that you can get for intellectual property is called a patent. This is a public document that provides a detailed description of an invention, provides owners with the exclusive rights to that invention, and then by filing a patent, you can prevent others from making, using, or selling that invention for 20 years. Now, there's a key difference between patents and trade secrets. Obviously, with trade secret, the whole idea is nobody knows how you do something. But with a patent, you have documented exactly how you create this invention in a public document that goes into the U.S. Patent Office. It just maintains a searchable archive. Anybody can go look at these patents and see how these kinds of things are made. And patents then give these exclusive rights to that particular invention. And you get some additional kinds of protections that if you can claim that somebody else created or reverse engineered or created some similar product that uses a very similar kind of technology than what I describe in my patent, then you can sue them for patent infringement. So yeah, we can sort of block this out into a comparison. So when we talk about copyrights versus patents, we can say you can copyright software and you can patent software. So what is protected in these two cases? First off, with a software copyright, the thing that's protected is the compiled program and how people engage with it. So the images on the screen, the form of the interface, these kinds of things. With a software patent, you're not protecting the program in terms of a compiled instance. You're not even protecting the display, but you are protecting the method around which this software was created, or the process by which, or the method through which some service is provided. So other ways you can compare them is getting a copyright expensive? No, but getting a patent is. You need to hire a patent lawyer, fill out paperwork. Is getting protection time consuming for a copyright? No. We'll talk about this in a minute. Copyrights actually come into being the moment you create the idea and write it down. Whereas patents, you actually have to do something. There is a positive action that has to be associated in order to gain a patent. And then is reverse engineering allowed? So can you reverse engineer the object program with a copyright? And the answer to that is yes, because you're protecting the compiled instance in the interface. But for patents, no, because it makes little sense to reverse engineer something when in theory the patent should already describe exactly how the thing is done. So once we've talked about the kinds of protections you're allowed, what are the ethical concerns around how these protections might be used? We'll look at this from two perspectives. The first one we'll look at is the concerns that you might have if you owned an idea. So you created a new book or a new story or a new piece of software or a new piece of music. What would you care about? You'd care about somebody copying it illegally, somebody stealing it from you, and then publishing it online for free. So then you no longer have control over the idea. You might care about being able to sell it for a profit. So you maybe put in a lot of intellectual labor or intellectual sweat in creating this idea and writing it down, forming it, and these kinds of things. And you want to have some sort of incentive or some sort of payoff for all that effort. So you may want to sell it for some profit. And there are some other concerns that I'll let you all discuss in the discussion forums. So yeah, some issue here is you wouldn't want the things that might make you unhappy is somebody else benefiting from your creativity and effort without paying. And from a societal perspective, we'd want to provide some incentives to create these things and maintain or ensure they have some sort of financial benefit for doing so. But there are times when unauthorized use might be allowed. So certainly you wouldn't want somebody stealing your idea and making money off of it. But again, societally, let's look at it the other way. When might it be okay for this kind of thing to occur, for unauthorized access to happen? And I think we can very clearly make an argument that's relevant today about if somebody created a vaccine for COVID-19, should they be able to restrict who has access to that? In a global pandemic setting, I think you can make a very clear and very strong ethical argument societally that somebody should be able to benefit from this. Certainly, they should get paid for creating for creating this vaccine. But should they be able to charge, $1 million per dose, or $100,000 per dose, or some exploitive amount for this vaccine? And I think the answer to that is no. So between they have to give up some control, or society is taking some control from you in order to use this idea, and that will probably be an authorized thing. And we've talked about this before in the case study when I asked you about the software developer at the CDC who finds some piece of software on GitHub that's not meant to be publicly available, but is by accident. Would it be okay for the CDC to use this software anyway? And I think the general consensus was yes, that it was okay. So yeah, the CDC is a really good example of this. But note, the CDC, Centers for Disease Control and Prevention, is a trademarked name, that the CDC sort of controls this, and you'd think there's real societal value in the CDC maintaining this trademark. So you wouldn't want some other random company or random person to be marketing either informational material or medicine under the name of the CDC, because then you as a consumer it'd be difficult to differentiate between what is legitimate advice from the CDC and what is advice from some company that's masquerading as the CDC. So when we talk about intellectual property, clearly the evolution of technology has had some significant impact on what it means to have intellectual property. So back in 1790, we saw that IP protections really only applied to books and like things of writing, books and prints. Because if you were going to have an idea for a story, you'd have to have somebody write it down or put it into a book and bind it, and then you'd sell that book, these kinds of things. But now with technology and the internet, a lot of things become much easier. It's actually trivial to make perfect copies of digital material. So if somebody sends you a book or an image or a movie, it's trivial to make a copy of it from one file to another, and then you have multiple copies of it. So the creator starts to lose control over the production or reproduction of her material. So digital storage is cheap, so it's trivial to store huge volumes of text, so huge volumes of images. I can hold vast libraries of books on a super small like micro SD card, right? So now it's when we start talking about claiming ownership, or when we claim ownership to more than I could possibly use, it is definitely the case that I could have more books on an SD card than I could ever read in a lifetime. That is definitely a possibility here. And then when we talk about compression, we can not just make perfect copies of digital material not in a trivial way, we can also make them smaller and easier to ship, easier to copy across the internet. So basically all kinds of distribution methods that you might originally have had control over like making copies of your books, or transcribing your music, or making recordings of your music, or videos of your movies. Before the advent of the internet and the personal computer, you had some control over how that content could be distributed. Now you have much less control. And not only do you have much less control, it's actually much easier to find material thanks to search engines. Peer-to-peer technology like Kazaa or BitTorrent makes transferring even large files over the internet extremely easy, and high-speed internet and broadband makes all of this even faster. And as we get smaller and smaller technology, we can record more and more things, either recording concerts or movies that we go to in person and then sharing them on YouTube. In some sense, this is okay. You'd want to be able to share your experience. But in another sense, if you go to a concert and you record their presentation, or you record the the performance, shouldn't the performers have some control over how that gets used? Especially so you see this a lot in the news now about performers having their music used along with political ads and political campaigns. And there is some argument that if a particular presidential candidate or political candidate is using a particular piece of music, that maybe the musician endorses that politician. So you'd want the musician to have some amount of control over that and say, well, if there's an expectation that playing of my music shows some amount of endorsement, then I should have control over who I can endorse in this way. So again, it becomes complicated, that you want to enable like random individuals to share their life experience, but you also want to empower content creators and performers with some amount of control over how their content gets used. Especially now when it's so easy for amateurs to create new derivative works using all kinds of technology, from iMovie to YouTube Studio, where it makes it very easy to create content, post content, and share content with billions of people across the globe. So now that we've talked about intellectual property, there are a couple or most of these questions you now should be able to answer. What does it mean to own property? So this is kind of a trick question in that it's difficult to describe this succinctly, but there are some shortcuts to being able to do so. What does it mean for something to be intellectual property? Why is tangible versus intangible things or ownership different? What kinds of reasons do we have to provide protections, both from an ethical standpoint that I talked about earlier and from a monetary standpoint? Describe the four protections. So we talked about like trademarks, copyrights, patents, and trade secrets. Why are copyrights and patents different? And why has the internet had such a major impact on how property can be protected? All right, so we'll break here, and I'll post the next half of the lecture, and you can watch that as well.